एयरप्लेन मोड पे कर
कर
दीजिए।
दिया मैंने, ऑलरेडी कर दिया।
माउस से क्लीन कर देना भैया।
Friends, very good afternoon to all of you. Welcome to this tele lecture on avoidance transactions. And here today will be dealing with undervalued transactions and preferential transactions in a CIRP matter under IBC. Friends, as we are all aware that Insolvency and Bankruptcy Code has brought in a paradigm change. Now with that, it also brings a lot of issues where the RPs and the promoters, they have to deal with it, including the committee of creditors. Now in a CIRP, when an RP is appointed, definitely it is his responsibility to keep the company as a going concern. Now when he keeps the company as a going concern, now he has to make sure that all the transactions which have been done, and he has to examine the transactions. In fact, it is his responsibility. If we look at the duties of the IRP or the RPs, the law very clearly mentions that it is the duty of the IRP or RP to form an opinion about the avoidance transactions, then determine the avoidance transactions, and then file an appropriate application as may be necessary. And this is to be done in a time limit manner, in a time-bound manner. Now, what is the time limit? The time limit is that the avoidance transactions have to be found out within 75 days. That means he has to make an opinion within 75 days. And then by 115th day, there must be a determination. Whether he determines or whether he appoints a forensic auditor or a transaction auditor, but it is the responsibility of the insolvency professional who is carrying out the CIRP, or he has been appointed as a liquidator. Both of them are responsible to determine that. And then by 135th day, then the application has to be filed, appropriate application is to be filed. But before we deal with those applications and the cases and those provisions, let us look at the history of the avoidance transactions. So I'll be dealing with my PPT. So here the avoidance transactions. Now avoidance transactions can be called as vulnerable transactions. They can be called as look-back transactions. And in some circles, we also call them as clawback transactions. Now, why do we call them as vulnerable transaction? Vulnerable transaction because these transactions have been done during vulnerable period. we call it as a twilight zone. When the company is not doing well, it is in financial strain, then in that case, there are certain circumstances where the promoters or the management may enter into certain transactions, whether voluntary or involuntary. So in a vulnerable state, when the company is doing certain transactions, they are known as vulnerable transactions. We call them as look-back transactions also, because for a very simple reason. Because the RP or the liquidator, now he has to look back. Like when we are riding a vehicle, there is a rear view mirror. Now when we drive, we look at in front, but definitely at times we also look at the back. Now the back is because we look at the rear view mirror. So here the rear view mirror will be known as the look back transactions. So there are transactions which have been incurred, which have happened 1 year before or 2 years before, depending upon whether it is a related party transaction or not. Therefore, friends, this is known as look back transactions also. Now let us look at the other aspects. The other aspects are that this genesis of IBC is from the BLRC, which is known as Bankruptcy Law Reforms Committee. Now here there are provisions to provide for its reversal. That if the RP or the liquidator is in a position to find out such transactions, then he has to make an application for the reversal. And the assets will definitely be part of the liquidation. Now, this concept of look-back transactions and the period of the time is prior to CIRP application. So whether the company is under CIRP or whether the company is under liquidation, friends, the time period of the look back starts from the date of the insolvency commencement date. Now, if it is a related party transaction, the period will be 2 years prior to that. If it is a non-related party transaction, it will be 1 year. So all transactions need to be scrutinized by the insolvency professional during that look back period. And not only verify, then he has to determine. Now, if some benefit has been given to certain party, then of course those transactions need to be reversed on an application which is made to the adjudicating authority, that is NCLT. Now, if we look at the next aspect, which is very important, and that is talking about that whether this concept is a new concept. Friends, this is not a new concept. Now, this has a genesis, of course, from the BLRC, but Companies Act 1956 already had a provision. If we look at the screen, we'll see that Section 531 of Companies Act 1956 talked about fraudulent preference. Similarly, we had Section 531A, which talked about voluntary preference, and both these transactions could be set aside by the High Court or later on, of course, under Companies Act 2013 by the NCLT. Similarly, if we look at the last part of the slide which you are looking at, Companies Act 2013 also has two sections, Section 328 and Section 329, and they talk about fraudulent preference and transactions not in good faith. So therefore, under IBC, friends, these are not new transactions, but these are transactions which have genesis, which are coming from Companies Act, particularly when the companies are in the winding up. Now, if we go to the next part of the slides, now we will see this is an overview. We all know that CIRPs are covered under Part 2. Now, preferential transactions, there are two sections, Section 43 and 44. Undervalued transactions are from 45 to 48. Then we have transactions defrauding creditors for Section 49, which is also dependent upon the undervalued transaction. It's not an independent section, so to say. And then we have extortionate credit transactions, Section 50 and 51. And of course, we have Section 66, which talks about the fraudulent transactions. Of course, in this session, I will be covering the preferential transactions, undervalued transactions, and the transactions defrauding creditors, which are dependent upon the undervalued transactions. So now, first of all, let us understand who is responsible for these avoidance transactions so as to find out. So the duty of the RP or the liquidator, if we look at preferential transaction Section 43 or Section 45, it clearly says that the application is to be made either by the RP or by the liquidator. So resolution professional has to file an application for avoidance of transactions in accordance with Section 25(2), and then liquidator is also responsible under Section 35(3) to investigate the affairs of the corporate debtor to determine avoidance transactions. This is what I was mentioning in the beginning, that whether it is under CIRP, these are the time limits. the RP has to make an opinion about the avoidance transaction. That means the existence. It's only a prima facie opinion within 75th day because everything is time bound. And then determination is to be done by 115th day. And then the onus is on the RP to file an application by 135th day because we all know that CIRP needs to be completed by 180th day. So this is all time bound, friends, and RPs are required to do this. They are under the obligation to do that. Then one more aspect. As I mentioned that there is a duty of the RP or the liquidator to file the preferential transactions or for avoidance of the undervalued transaction. Now friends, one more aspect. Under section 47, supposing the liquidator or the RP does not find out such transaction, does not file this application, that means he misses this kind of a transaction. Then what happens? Then there is a section which is section 47, which clearly talks about that in case the RP or the liquidator fails to report the undervalued transaction, it is only related to undervalued, then the adjudicating authority is directed to advise the board to initiate disciplinary proceedings. Now, the disciplinary proceedings can also be initiated if the RP or the liquidator fails to file or report such undervalued transactions. So therefore, I would say it is the duty of the RPs or the liquidator, and they must perform this duty with the complete sincerity. Right. So therefore, if we move on to the next item, talking about the preferential transactions. Now, who can file the application? Now, this is also important. For preferential transactions which are covered under section 43, resolution professional or liquidator. So this is their responsibility. Similarly, under undervalued, of course, the primary responsibility is that of the resolution professional or liquidator, but the undervalued transaction section also provides that a creditor, member or a partner of a CD under section 47 can also do it if the resolution professional or liquidator fails to do that. And I mentioned the consequences of not filing that. Now, if we look at the preferential transactions, let's understand what is the meaning of preferential transactions. Now, preferential transaction is a technical word. In a simpler word, I can define that, but let us look at what are the parts of section 43. Now, section 43 has got important concepts which need to be understood. Number one, what is the meaning of the preference and how it is going to be determined? Section talks about that. Second, these transactions must happen during the relevant period. So how the relevant period is to be calculated, that is also mentioned in section 43. Similarly, whether the transaction which has been done, whether it is a related party or not, of course, that is also to be seen. That is very important for this section. And then good faith exceptions. Of course, all transactions will not be covered. So there are certain good faith exceptions which are also covered. So this section also says that not all transactions will be covered, but certain transactions will be excluded from the purview of preferential transaction. And then, of course, it talks about the application to be made and what orders can be passed. So section 43 gives us the conspectus of the preferential transactions, what is covered, what is not covered, what is the relevant period, whether the transaction is a related party or not. So what is the relevant period for that? But the application is to be made under section 43. The orders which the adjudicating authority can pass are mentioned in section 44. So I think anyone who wants to know about preferential transaction, he or she needs to study section 43 as well as section 44. So now coming to the preferential transaction sections, which is again a very important section which we need to understand that what exactly is meant by the preference. But before we do that, let us look at, this is the opinion to be formed, whether a preference has been given in a transaction by a CD or not. So first we need to understand the meaning of the word preference. Then it must be done during the relevant time or the relevant period, or it should, whether we have to understand whether it is a related party or it is to a non-related party transaction. Now, what is the meaning of the preference? The meaning of the preference or the deemed preference, friends, is given in section 43 itself, and it says, if you look at the presentation before you, the first item clearly mentions transfer of property or interest in the property of the corporate debtor. Now, this is extremely important. So there must be a transfer. Number two, it must be for the benefit of a creditor or surety or a guarantor. So it must accrue to the benefit of a creditor or a surety or a guarantor. This also needs to be satisfied. The third condition, which is also extremely important, is, and some people do miss this, it must be on account of antecedent financial or operational debt or other liabilities. So this is very, very important, that there must exist an antecedent financial or operational debt, and a transfer of property has taken place pursuant to the antecedent financial debt, which is extremely important. So if these conditions are satisfied, definitely the transaction will fall within the domain of preferential transaction. Now, not only that, if we look at the other conditions, that the property must be the antecedent financial debt should be owed by the corporate debtor. Now that's also important. And then the last condition, which cannot be missed, is that the effect of such transfer is putting such creditor or surety or guarantor in a beneficial position than it would have been in distribution of assets under section 53. So friends, in a simpler word, I can explain that preferential here means that preferring one creditor over the other creditor. Now, I can give you a small example, that supposing an amount was due to X, 20 lakh rupees, and amount was due to Y, say 10 lakh rupees, and both are operational creditors who have supplied goods to the company. Now, if the corporate debtor prefers X and they make the payment of 20 lakhs, but they don't pay any amount to Y, now if the company comes into CIRP, or ultimately if it goes to liquidation, we are all aware, if the company comes into liquidation, then the money is distributed in accordance with section 53, which we call it as waterfall mechanism. So both the operational creditors will fall into the same category, and they will receive the money, if available, in proportion to their amount which is owed by the company. Now here, in case if the X has been preferred and the payment has been made over Y, then of course it will be considered as a preferential transaction. So this is extremely important, friends. So we need to really understand what are the elements. Of course, when we speak about transfer, the definition of transfer is given in section 3, subsection 34. I don't have to read that. It's a very detailed definition. But another important definition which has been given in the IBC is section 335, which talks about transfer of property. So here the transfer of property means transfer of any property and includes the transfer of any property and creation of any charge upon such property. So either it is a transfer of the property or transfer of any interest in the property. Now, the benefit of a creditor, I can give few examples. Creditor who receives a check or payment from the debtor against outstanding invoice in preference to the other creditors. Goods are returned by the debtor to the creditor because he is not able to consume it and he returns that. But obviously, this has been given a preference. And lastly, is an obligation of the creditor is reduced by the debtor. So these are certain examples which can be given. Now, one of the important aspects which we saw was antecedent financial debt. Now, what is the meaning of antecedent financial debt? I think you can see it on your screen. Payment or transfer made on a pre-existing debt. Now, this is one of the conditions. Pre-existing debt or obligation as opposed to cash on delivery or cash in advance payment. Now, if transfer is made after the debt or obligation comes into existence, then the transfer is deemed to be made for or on account of antecedent debt. So this is extremely important, that there must exist antecedent financial debt. Now, the creditor receives more as contemplated to under liquidation. This is also to be compared. As I just explained, under section 53, if the company comes into liquidation, then the creditors get their money in accordance with the priority as determined in section 53. Of course, secured creditors have the topmost priority after the CIRP cost and the liquidation cost. But this is very important. The comparison is to be made, in accordance with section 53. So if under section 53, I was supposed to get only 1 lakh rupees, but I get 10 lakh rupees, that means there is a preference to me. So this is a very important element which cannot be missed in these particular circumstances. Now, friends, this is one part is this. Now, what are the defenses? It is not that every transaction of this nature will be considered as a preferential transaction. Now, at the end of the day, corporate debtor is doing business, and the supplier who has supplied the materials is also doing business. So if it is done in the ordinary course of the business of both the creditor as well as the debtor, corporate debtor, then in that case, this transaction will be outside the purview of a preference. Similarly, if this transaction creates a subsequent new value, so this is known as subsequent new value defense. And then there could be a contemporaneous exchange defense. So these are the three defenses or exceptions which are allowed. Now, ordinary course of business is definitely a subjective test. The controlling factor will be whether the transactions between the debtor and the creditor both before and during the relevant period were constant. No, it should not be an extraordinary transaction. So transactions may be considered ordinary for the purpose of ordinary course of business defense if they were consistent with the course of dealing between the parties. So if I'm paying a creditor, say within 30 days, now if I make the payment, say on 31st day, I think it's an ordinary course of business. Then it cannot be treated as that it is outside the ordinary course of business. So the courts generally consider, what is the criteria which the court considers, what are the factors rather which the court considers to determine whether a transaction is an ordinary course or not. A, prior course of dealing between the parties, amount of the payments, timing of the payments, and lastly, circumstances surrounding the payment. So circumstances will vary from case to case. And these are the factors which additionally, these are the two more factors which are considered. That means if there are first-time transactions, now first-time transactions will be generally considered as ordinary course. And terms and conditions, of course, need to be examined. So payments which are made in accordance with the terms are considered as ordinary course of business. But if you are paying out of the ordinary, then of course it will not be considered at this. Now, what are the steps which are to prove? Now, first is that there has to be a preparation of the payment history. So to determine whether it's an ordinary course of transaction or not, ordinary course of business transaction or not, a payment history is required. Then we will compare the days which are outstanding prior to the preference periods to the days outstanding during the preference periods. And if those average days are in excess or lower, then of course it will be seen whether they are consistent with the normal payments or not. Now, these are the few factors which may go against proving the ordinary. That means reduced terms during the preference period. So normally you pay within 30 days, but if you pay within 15 days, then it will not be treated as an ordinary course of business. Change in the mode of payment could also be considered as that it is not an ordinary course of business. Collection action. Right? So threats to cut off the supplies or the shipment's decision to enforce the credit limit. So if the threats are accompanied, then of course under a coercion or under a threat, if the payment is made, then it will be considered as the preferential transaction. So increased number of invoices which have been paid during or shortly before the commencement of the preference periods, because there could be an arm twisting also, or the promoters may do it voluntarily. So here the intention is not relevant. Now, the second aspect is that the transaction will be outside the purview of preference if it creates a subsequent new value. Now, what do you mean by new value? New value definitely means new money or money's worth in goods, services, or new credit. So this is extremely important. So if it is creating a new value, like supposing a loan is given for a purchase of new machinery. So now the company has got a loan against the machinery and the machinery was bought, so it has created a new value. So it's not the old value which has been given against the previous debt. So it's a new debt and a new transaction, or the new goods have come into the company. So code allows the creditor to offset against a preferential transfer which creates security interest in the property. So this is also very important, that when a security interest is also created, it is also treated as a transfer of property. But if it creates a new value, then it is outside the purview of preferential transaction. So now what is the relevant period? As I mentioned in the beginning, there is a relevant period. So related party, it is 2 years preceding the insolvency commencement date. For non-related party, the period has been defined to be 1 year preceding the insolvency commencement date. Friends, this is a very small case study. Here, one company obtained an unsecured loan, working capital loan. So please understand, it was a working capital loan for rupees 50 lakhs and no security was given on a particular date, that is 15th July 2019 as an example. Now, the person who gave the lender who gave the loan, they realize that the company is in difficulty, so he must obtain some security interest. So the security interest is created, say 2 days later. Certain machinery is charged. Now the loan is given for working capital, but the machinery is charged as a security interest. And the CIRP commences, say, almost 11 months later. Now, whether this transaction is to be considered as a preferential transaction or not, now there are certain steps which needs to be seen. Now, what are the transactions which are the elements which have to be seen? Does this transaction fall within the relevant time? The answer is yes, because it was within 1 year before and because it was a non-related party, assuming that. Is there a transfer of property or interest for the benefit of creditor? The answer is yes. Is there an antecedent financial or operational debt? Well, of course, there was a loan which was given working capital, so security interest was given against that. So there is an antecedent financial or operational debt. Was the transfer for an account of the antecedent debt to the creditor? The answer is yes. Has the transfer put the creditor in a beneficial position? Definitely yes, because a security interest was created. And was it registered with the IU within 30 days? This is also to be seen. Of course, let us presume that it was registered with the IU. Now, but we have to see whether this is an ordinary course of business or of financial affairs or not. That will depend upon the facts and circumstances of each case. Then, security interest in the property secures new value. Well, it was given for a working capital. So in working capital, some debtors or stocks must have been bought. Was it given at the time or after the signing of the security agreement? Answer again is yes. Was the loan used by the CD to acquire such property? Here, now that condition is not satisfied. So having not satisfied this condition, so I would say that this would be covered as a preferential transaction. So all the conditions, friends, are required to be satisfied to treat it as a preferential transaction. So this is extremely important. All of us have to see all these things. So I have just given a small, you can say a chart where the answers are yes to most of the questions. And the last is whether the loan was used by the CD to acquire such property. The answer is no. So therefore, this will be considered as a preferential transactions. So what orders can be passed? Well, the adjudicating authority, the orders are very simple. The property which has gone, it can come back. If the property has been sold, so money can come back. If somebody has obtained the benefit, that benefit can also come back. Or if the security interest has been given, that can be directed to be released or discharged. Now, if we look at the undervalued transactions, so let me also devote certain time to undervalued transactions. So undervalued transactions are slightly different from preferential transactions. Undervalued transactions clearly mean that okay, let's look at this. RP or liquidator must examine the transactions. Obviously, these transactions must be during relevant period. And to determine whether they are undervalued or not, of course, there is a check. Application is to be made. Then those transactions can be declared as void and the transactions can also be reversed. So now, what is the meaning of undervalued? The simple meaning of the word undervalued is that if a transaction or a property is given at a lower value than what it can fetch in the market. So if it is a gift, so obviously it can be considered as undervalued. Transfer of a property of a CD to consideration significantly lower than the value of consideration provided by the CD. And it is not in the ordinary course of business of the CD, then adjudicating authority may, now the word is may, because there is a judgment of NCLAT also where a challenge was made that the NCLT or adjudicating authority came to a conclusion without appointing an expert. So NCLAT, the appellate authority, has held that it is not mandatory in each case to determine the undervalued transaction that an expert or independent expert has to be appointed. It is the discretion of the adjudicating authority because of the presence of the word may in that particular thing. So this is also needs to be looked into. Now, if we look at the related party and non-related party, the relevant period, friends, is quite similar. 2 years in case of related parties, and in case of non-related parties, transactions made 1 year prior to the insolvency commencement date. Now, what are the orders which can be passed in case of undervalued transactions? Well, of course, adjudicating authority can say vesting of the property back to the CD, release of the security interest, payment of benefit received to the RP or the liquidator, or payment of the consideration as determined by the independent expert. So these are the very important aspect. So now the right to apply is with the creditor, member, or partner of CD. Now that's also very important, and this has to be done. And as I already mentioned, that under section 47, if the liquidator or the RP fails to do it, then it needs to be, it's a serious issue and the matter can be referred to the disciplinary committee. And then the third is transaction defrauding creditors. If it's a undervalued transaction first, then transaction defrauding creditors can also be brought back to the company. They can be set aside. So friends, it is the duty of the RP and liquidator to look at both these transactions, preferential as well undervalued transactions. Now, if they don't do it, it's a serious consequences. It is mandatory for the RP and the liquidator to do that. And I think the promoters should also understand the consequences of this. So if they do these kind of transactions, so then they are going to be in trouble, because those transactions, they can be directed to bring back that money to the corporate debtor. So friends, thank you so much for hearing patiently. And this was all about preferential transactions and undervalued transactions. So I must thank IBBI for inviting me for this particular lecture. Thank you so much.